Hello everyone, hope you're doing well. Welcome to Chapter 8, Workplace Law and Ethics. This is something that touches home for me, being employed by a large healthcare system for a number of years. A lot of the terms in this chapter uh, were not new to me, but some of them were, and I learned a lot. So, I try to go through the chapter each time we go through it personally, and I'm really enjoying this one so far. All right, you can take a look at the learning objectives because we're going to go through each thing, but some of the stuff we talk about in this chapter is professionalism, of course, in the workplace. Some of those things are pretty common sense, but should be, of course, heeded. And when you talk about an ethical perspective of how you work and your relationship with others, it's pretty clear you need to avoid discrimination, violate patients' privacy, you're respectful of cultural differences, and then, of course, respectful of religious practices. So HIPAA, of course, in 1996 offered up a lot of regulations in regards to privacy in the workplace. Opening a medical file that's not yours for a reason. Well, even if it is yours, there's some rules and regulations behind that too. But depending on the organization you work for, and that it can differ, and I think depending on state practice too. But HIPAA, of course, prevents you from opening a file and just taking a look unless it's a need to know basis from the patient's perspective in their healthcare delivery. Some cultural considerations too that you should worry about, making sure there's no stereotyping, bias. You don't judge people when they're in the healthcare setting, and understand that different cultures have their own practices for personal hygiene. And there's differences. I worked in Alaska for an extended period of time, and there was different cultures up there that I had to heed in regards to how people expected to be treated, and we have to make sure that we treat people in the way that they expect to be treated based on their distinctions. And that doesn't mean you don't provide the right care for them, but it might mean that you do things a little bit differently. All right. So, something to consider as well, communication can be a challenge for some people because they might not speak the same language. So, one thing that you're going to be regulated to do is make sure you have a translator, and often a translator has to be someone that's certified in that regard. Some people have tried to bring translators, I know, into our healthcare setting that are just family members, and we really shy away from that just due to the fact that they have to be certified because we want to convey the right message, and sometimes cultural restrictions can pose difficulties in regards to that. All right, I'm going to kind of move fast here. Some other religious considerations to consider: patient autonomy, right? People can say no to medical care if they don't believe in that practice from a religious perspective. That's their right to do so. And it's never appropriate to judge someone's belief based on their religious upbringing and thoughts. And we have to abide by those practices. That's what is so good about, of course, delivering healthcare here in the U.S. We can adhere to these differences for people, and the system should be okay with it. Some other things to remember, effective hiring practice. We have to have clear policies when you're hiring. Usually there's a two-tier screening process, so you screen people based on, of course, their application, and of course, hopefully, if they make it to the next round, initial interview and a follow-up. But you have to really make sure that you're hiring based on, skill set and need rather than just hiring because you like the person or someone that you would like to work with. There has to be a process, and that's why there should be job descriptions, and people should follow the job description and based on the right person to be hired to fulfill that job subscription. Um, I always say don't ever ask questions in the interview process about age, birthplace, address, marriage, or maiden name. You just don't do it. Just stay away from it. I know it says legal and illegal. Just consider them all illegal and don't ask anything in regards to that. Same thing with this. Children, height and weight, race and color, religion or creed, and whether or not you've been arrested. Some of these things don't really comply to the work that they're doing now. In regards to arrest records and such, there are regulations behind healthcare delivery. I think if you have convictions in some areas, you're banned from certain licensure qualifications, but that's different than going through the interview process, and that comes after in regards to when they do a background check. So that there's a process for that. So there are regulations behind that, but just because you've been arrested doesn't mean you can't work in a healthcare setting. Same thing with citizenship, been convicted, handicaps, organizations, languages, military experience. Don't really ask any questions related to this. This stuff comes up in a application process and then in the overview once they're done with the interview itself. Once you offer the role, that's when a background check will pull up some of this information. You don't need to ask someone whether or not they've been convicted of a crime in an interview. That's not appropriate. That has nothing to do with the job. Wait for that to come about later in the end during the background check, because that's usually how large healthcare systems perform their interviews and their process. All right. There are, of course, federal regulations for people that act in a healthcare professional setting, so make sure you're aware of those. And the EEOC is important as well, Equal Employment Opportunity Commission. There's the laws that affect recruitment, placement, pay plans, benefits, all that kind of stuff. What we talked about in your interviews, that's a part of the EEOC as well. So that'll be a test question, so make sure you understand and know about the EEOC. So there's differences depending on the state. Some employment is at will. So employment takes place at will of either employer or employee, and employment may be terminated at will at no time for no reason. So the at will states have a little bit of an edge in regards to holding their employees accountable, but there are some states that are not at will employment. This is not really a test question, just more of an FYI. Title VII of the Civil Rights Act is also important. It's one of the things that went through back in the 60s to prohibit discrimination, unfair treatment of race, color, religion, gender, or national origin in regards to the workplace. Make sure you're aware of this law. A little bit more about it. It also established the EEOC that we talked about earlier. All right. A little bit more in regards to civil rights. There was a Civil Rights Act in 1991 as well, and it permits the court to award compensation damages for loss of income or emotional pain, depending on the practicing discrimination. And this has been something that's brought up quite a bit in healthcare, and you can actually see legal cases about it if you just do a quick search on Google Scholar. All right. EEOC, or EEOA, I'm sorry, Equal Employment Opportunity Act. It's something that goes further than Title VII. So when suits are taking place because of Title VII, feel free to take a look at that. Pregnancy Discrimination Act. I'm not going to go through this, but I'm sure you're aware you got to treat pregnant women as they would any other employee. There's also some states have some benefits as well for the other partner in regards to their leave as well. Don't feel like you have to know that from a state-by-state basis, but make sure you understand the Pregnancy Discrimination Act in 1978. Same thing with the Age Discrimination Equal Employment Act of 1967. Tons of stuff out here. Rehab Act of 1973. That's a disability type act in regards to making sure people are taken care of, those that have a disability. And the ADA, which was, of course, enacted in 1990 and then amended in 2008. But if you have more than 15 employees, you can't discriminate against people with a disability. But there are Age Discrimination Act, Rehab Act, all that kind of stuff plays into the ADA Act. So even if you have less than 15 employees, you're going to get in trouble for discriminating against people who have a disability by any nature of the term. All right, the NLRA, you can read through that. We're kind of going through a lot here. So that has to do with, of course, unions, unionization. All right, it's been around for a long time. So employee health and safety, those are regulated both on the state and federal level. OSHA is a big thing, and especially in healthcare systems. It was started in 1970, but it has standards in regards to, bloodborne pathogens, how the workplace should look, and in healthcare that's really important, especially when you refer to all the things on a patient care standpoint. Some of the things they oversees, urine, stool, sputum, nasal, all that kind of stuff, sweat. If there's visible evidence of blood, right, all those things must be taken care of in a sterile manner. CLIA is another thing, the Clinical Laboratory Improvement Act of 1988. Regulation of all clinical laboratories and human specimens. Anyone that's ever worked in a healthcare setting, if you have a CLIA lab, you do testing, you have to have a CLIA certificate, and you got to be reviewed from making sure that you're safe to provide that care for patients. HMO, we're not going to go through that, but make sure you take a look at it. COBRA, a lot of people, if you've lost a job, you've heard of COBRA. It, of course, makes sure that people have healthcare coverage or have the option for healthcare coverage up to 18 months when they lose their job. The Drug-Free Workplace Act of 1988, you can read through this, not a test question, but something that could come up. Social Security Act 1935, it's compensation, right? Put back, kind of like a retirement plan for people. It's paid by the employer and the employee. It has several programs. Currently right now it's a challenge because people are living longer, but hopefully this is something that continues to be in place in the future so people can rely on it for retirement purposes. All right, the Fair Labor Standards Act of 1938, that might be a test question, but it regulates employee benefits, establishes minimum wage, overtime pay, and sets hours for employees when they can and can't work. Affects only full-time hourly employees, right? This was put in place a long time ago during the Industrial Revolution time period because, if you look back in history, people were working really long hours and it was unsafe conditions. The Equal Pay Act of 1963 is another one. It has to do with the Fair Labor Standards Act. You can't pay people based on gender differences. They have to be paid the same based on productivity and job role. Unemployment compensation is also something that is provided by most employers. Take a look at this. I'm not going to go through FICA, but you can look at it. Workers' comp is another thing I'm sure most of you are aware of. Protects workers from families from financial problems resulting from employment issues. Lots of stuff here. FMLA we've already talked about. No, we actually haven't talked about FMLA, but FMLA is something that you hear about a lot. Allows the mother and father to have an absence up to 12 weeks when a baby is born. That happens quite a bit, of course, in the healthcare setting. If you oversee a lot of people, I deal with a lot of FMLA, and that's something that's regulated and a benefit to our employees, which is great. And TALA, this is a huge one for the healthcare setting. If someone shows up, this is a section of COBRA, if someone shows up to the ED, we can't dump the patient. We actually have to do a medical screening exam on the patient, and that's important because when people show up, we want to make sure we take care of them in a way that is conducive to what they need, and it protects patients that are unable to pay, which is a great thing. The Fair Credit Reporting Act of 1971, that's guidelines in regard to credit information. Don't worry too much about that. Equal Credit Opportunity Act, I'm not going to go into that as well. There's a couple of, using collection agency. This is not something that we're really going to take a look at. You can look at bankruptcy if you're interested in that as well. And the Federal Wage Garnishing Act of 1970. Don't worry about claims against the states. We've talked about the statute of limitations, but there are statute of limitations depending on the state, and there's federal statute of limitations as well, depending on where the crime is or who's the person getting convicted, and whether or not it's a state or federal crime. But you can't convict someone of stealing a candy bar 50 years ago, as an example. There are statutes of limitations for certain things, and some things don't have statutes of limitations, like murder, as an example, doesn't have a statute of limitations in some capacity. So that's something that you should be aware of, something that's going to be a test question. There's different variations of this, but it's something that's important to realize. All right, that's a lot of information, but you have the opportunity to read through the workbook, of course, and to read through this PowerPoint and gather notes and make sure you're ready to go for whatever questions might come up and information on an exam. So I tried to go over the things that I've seen on the exams, the things that I went through a little bit quicker, and not things that's relevant to healthcare or things that you might see on an exam, whether or not it's a final exam or a midterm. If you have any questions, don't hesitate to reach out. This was fun. I appreciate you guys listening in. Chapter 8, Workplace Law and Ethics.